Yes, please.
For proceedings in which cameras were present, the comments of individuals who testified at the public hearings held by the committee, and the written submissions of others who were unable to testify at the hearings, the committee's review of data relating to applications for audio-video coverage, and 6, the personal audio-video coverage of court proceedings serves an important educational function. The more you get about the courts, the better, so you can see how bad they are. The wider exposure to the courts that camera coverage provides engenders a deeper understanding of legal principles and processes. Well, you know who needs that? The judges. Which, in turn, leads to increased public respect for the justice system. That'll be the day. Nobody could have any respect for the justice system as it is today. Camera coverage also promotes the values underlying the principle of the public trial in the First Amendment, thereby fostering public scrutiny of court proceedings. Boy, do we need that, and that's why we don't have cameras in the courtroom with the judge in Gracia courthouse. They don't want scrutiny of court proceedings and serving as a deterrent against injustice. Additional benefits include the salutary effect that the presence of cameras has on the behavior of judges. Indeed it does. And attorneys. Once they know a camera is there, they behave a whole lot better, or once they know that witnesses are there, they behave a whole lot better. That's why I've told you, never go to court alone. An increase in the accuracy of reporting by broadcast and newspaper reporters, we certainly need that, and the educational tool that videotapes of court proceedings provide to judges, attorneys, and students. So I think you got the drift here. I'm going to continue reading it. I'm going to copy some of this, and I'm going to send it to our administrative judge, Angelo and Gracia. I've read way up to there. Wow. We must have cameras in the courtroom. I had to call up 3 times, or twice anyway, to get this report. For you. Serious, we must stop for some jokes. And what happens? Why do geese fly south in the winter? Do you know? Why do geese fly south in the winter? Because it's too far to walk. And the young lady was asked by the young man, what kind of sports do you like the best? And she said, the kind who spend their money and go home early. And a mother asked 2 elderly women to sit with her daughter because the mother wanted to go do something quickly and come right back. And so as the 2 elderly women and the little 8-year-old sat in the room together, one of the women said to the other one, she's not very P-R-E-T-T-Y, is she? And the little girl says, no, but very S-M-A-R-T. There is a public forum, and we very often read announcements for people on this program. When lawyers steal, Long Island, with the state's highest theft rate, is especially vulnerable. This is put out by Americans for Legal Forum. Gary? Gary?
Yes.
Will you wiggle those things again so we get a picture?
No, the thing that was wiggled is with you.
Over here, wiggle, please, whatever we did before. See if we can get a picture back. by judges and lawyers is proven by Operation Greylord. Judges and lawyers were convicted of committing criminal acts, including the taking of bribes. Operation Courtroom occurred in Dade County, Florida. All across America there are reports of corruption and unethical judges and lawyers. Is this confidence and trust of the public in the judicial system being destroyed by corrupt judges and lawyers? What are the present-day results of corruption within our courts? Freedom and our constitutional rights. I lost the audio. Corruption and the following facts or fictions are being talked about all across America, and particularly within the many grassroots organizations that have been born because of the public's concern for the lack of integrity, righteousness, and justice within the legal community. We ask our readers to decide if the following 12 statements, questions, are facts or fictions. 1. A crime epidemic is sweeping across and infecting this great nation of America. Fact or fiction? What do you say? 2. Some lawyers and judges are reaping windfall profits from the crime epidemic. Fact or fiction? Many lawyers have become filthy rich by reaping windfall profits from the crime epidemic. No criminal organization can operate for very long without the guidance, direction, and protection of a lawyer. The American Bar Association and its lawyer members have an illegal monopoly on the practice of law in America. Over 243 million American citizens, 90%, do not have adequate, effective, meaningful, or honest access to the courts of America. If taxes, it takes one's full week's salary, I'll start over again. It takes one full week's salary of an American citizen who earns minimum wages just to pay a lawyer for just 1 hour of the lawyer's time. Didn't we find that out in the injustice of the Colabella Court awarding the crooked Edwin Purvis $4,500, $200 an hour lawyer's fees? Didn't we find that just? Yes, it was Wednesday. Here, in your own turf, Westchester County, Supreme Court. The American Bar Association and its lawyer members make up the largest criminal organization operating in America. Lawyers who are members of the American Bar Association steal more money from American citizens than the mafia and all organized crime combined. Lawyers who are members of the American Bar Association kill more American citizens with their pens and pressures than the mafia and all organized crime combined kill with their pistols. Lawyers who are members of the American Bar Association put more prostitutes on the streets of America with their divorce courts than the mafia and all organized crime combined does with their criminal prostitution. Lawyers who are members of the American Bar Association regularly destroy and butcher American families for profit in their slaughterhouse, divorce, and bankruptcy courts. What our readers can do. We ask our readers to carefully read the above 12 statements, questions, and to mark each statement question as being either fact or fiction. We ask our readers to please write us a letter to the above address or send us a fax to 10904-643-5190 and give us your opinion of whether or not the above 12 statements are facts or fictions. Well, you can call the number that you see on the screen. That's Americans for Legal Reforms, Harvey Cash and Carl Lancesera, and it's in Long Island. Next week, we will read you pages 3 and pages 4 of the Corruption Chronicles. This is the schematic that Franco de Rose drew for me, because he has been promoted and he's going to move up, and I've got to do all the things that he's been doing for me. I have to do them. I have to do the patches, the video out of here and into here, connect the tie-in into the TBC, the time-based corrector, connect the time-based corrector into the control room, connect the control room into the 3/4 inch recorder, connect the tie-in on the right side into mix 1, connect the tie-in on the left side into mix 2. I got to learn all that. Plus I got to push all the buttons. I have to patch in the video, and I have to patch in because I'm losing Francisco. Francisco is irreplaceable. Nobody can replace. Excuse me, Franco de Rose is irreplaceable. Nobody can replace Franco de Rose. I'm going to tell you some jokes, and then I'm going to, I would like to have the London Philharmonic play and the chorus sing the hymns through the rest of the program, but the audio deck at TCI makes my audio tape flip over and play the other side. In essence, it doesn't flip over, but it plays the other side. And it keeps doing this over and over again. But when I play my audio tape in my own little recorder, it's just fine. And of course, it's magnificent in stereo. And I've asked Borden's to Borders Books to order a new tape, and they haven't done it yet. And I don't see why it has to take them so long. So we'll play hymns for you, and I think they'll be by the Mormon Tabernacle, Mormon Temple Chorus and Orchestra. They're good, but nobody can touch the London Philharmonic, of course. And Marilyn says, I expect my husband to be 30 years from now exactly what he is today. And her friend says, that's unreasonable. And Marilyn says, that's what he is today. And the husband came home from work and he was all tired out, and his wife says, did you have a hard day at work? And he said, yes, they gave us aptitude tests, and I flunked mine. And his wife says, that's terrible. He says, yes, it's a good thing I own the company. And the last joke is the man came out of the pet shop and he's holding a little Cocker Spaniel in his arms, and he encounters a friend of his, and the man says, what do you think of the Cocker Spaniel that I got for my wife? And his friend thought a while and said, that's not a bad trade. God bless you. Take care of yourselves. And keep your courage flaming. Don't let them win. Don't. And they're breaking the White Plains noise ordinance. 3C, 2B. Today is July 3rd.
What are you doing? What are you doing? What are you doing? Stop it! Get the camera away from me. Get that thing away from me. You are a maniac. I'm sorry, they don't mean to do Stop! Make her stop! I'm gonna freaking grab the camera from you if you don't stop. Are you kidding? What are you doing? Hello?
Okay, the time is 5:50 p.m. The date is July
Why are you
3rd,
taking my license plate?
1995,
What?
on Monday.
You're nuts.
This is the second time this has happened.
I'm gonna kill this lady. I'm really gonna kill you. I don't care. I don't care. Why don't you care?
I think these are the ones who were smoking cigars a couple of weeks ago. (5:57 p.m. July 3rd, 1995, Monday. Fade. It's about 5. It's about 6 o'clock. Yes, these are the ones who were smoking the cigars. 6 o'clock. She's in 2B, the one who just clawed her fingers. She's in 2B. Patricia Calabrese. The others are her visitors. And that's Francisco and Francisco. They were here the other night, and they were harassing. And this one just broke down the shrubberies and came up to the window going away in that white car. That one. So the time is 6:01 p.m. The date is July the 3rd, 1995, Monday. And that's at 21 Greenridge Avenue. Nella Alpucci sealing the parking place that belongs to Walsh. And she has a parking ticket, it looks like. She should get a parking ticket here. But she's always stealing somebody's parking space. She just got out of the car, front door, and went around to the truck. And I'll show you coming around by the south window. Going into 4B. And what is the time? 7, can't see it, 7:31 p.m. July 3rd, 1995, Monday. Today is July 4th. These calls have piled up for a long time because of so much law breaking, so many crooked lawyers, and so many corrupt judges, and all the work that they cause, and all the life they ruin. And that's for quite a few of us. So let's play these calls back.
15 calls, 6 messages, 8:01 p.m. Thursday, June 29. Okay. Message 2, 10:20 p.m. Thursday, June 29. Hi, I think I'm going to Happy Work. My name's Leah Pollack, Leopollack. My address is 20 Woodland Place, Woodland Place, White Plains, New York, 10606. My telephone number, well, I'm not allowed to give it out, so I was wondering if you could just send me the Glendora Happy Book, please. Thank you. Bye. Message 3, 10:16 p.m. Friday, June 30. Message 4, 9:10 p.m. Saturday, July 1. You got problems. Message 5, 9:11 p.m. Saturday, July 1. Message 6, 6:55 p.m. Monday, July 3. Hi, Glen. You must be out in the sunshine. It's 6:54. Everything's done now. I'm going to start on the reduction. Everything's done but the reduction.
just get his license. Let's just get the license. MZ2198. Did I give you the time on that? It's 8:21 a.m. on the 5th of July, 1995, Wednesday.
Yes, I did. Yes, I did.
I think they know. What? What happened to good old-fashioned rake? Did you ever know what happened to that, Frank? They don't make rakes anymore?
Looking for July 11th. I just think one size is great. She's been separated for 6 months, right? And I was with her when she left us to walk up this certain block. He's supposed to be at least 100 feet away from her. And he started arguing in the street. So that's that happened.
$1,807 programs later, and that's a whole lot of work. There are so many labor-saving devices on the market today, you have to spend half of your life working to pay for them. And there was a rummage sale at the church. And the woman came over to the minister and she said, "Do you see that little room right over there? Well, I sold everything in that little room." And the minister said, "That's the cloakroom." And some young co-eds were being interviewed by a reporter and were asked, "Why did you choose this college?" And the co-ed said, "Because it has the best ratings." And the reporter says, "The best ratings? In what way?" And the co-ed said, 10 men to 3 women. And folks, about Glendora versus Scott Lord, Conrad Duberstein, who is a judge, the head judge of the Eastern Bankruptcy Court, Robert John Hall, who is a judge in the Eastern Bankruptcy Court, and he's in Westbury, and Harold Jones, who was a former United States trustee, and Neil Mann, who was a former assistant United States trustee, Andrew Maloney, who was a former United States attorney, Teresa Kavanaugh, who is a United States trustee now in the bankruptcy court. This is all the Eastern District, which encompasses Nassau, Suffolk, and Brooklyn. Who else is on there? Jan Stahl, Jeffrey Barnes, the 2 people who committed fraudulent conveyances with Scott Lord, Bert Stutchen, their lawyer, Lisa Shrewsbury, Richard O'Connell's lawyer. Richard O'Connell was the trustee of the bankruptcy. Now we have Judge Gerard Vitale, United States District Court here in White Plains, now banished to Connecticut. Judges Winter, Jacobs, and Cabranes of the Second Circuit, United States Court of Appeals. And Joseph Derby, who is a retired New York City policeman working for Pinkerton, and first people as they enter the bankruptcy court in Westbury and Canal Road. Okay, what is happening there this week? I told you over and over again, it was dormant until the Labor Day, because that's how long it takes the New York State Court of Appeals to decide whether they're going to give me motion to appeal the rotten decision of the Appellate Division, Second Department, and who would that be? I think that would be Sullivan and Ritter and Goldman and Altman. They do bad work. They shouldn't be on the bench at all. They don't know what justice is. So, and then lo and behold, this week, 4th of July week, comes from the Appellate Division, comes from the New York State Court of Appeals. These 3 papers that they group them all together. You know, it's sloppy work. It's 6-year-old stuff. They group 3 lawsuits all together, just the way they did before. Nicolai and Ruskin and Donovan and I guess that was it. Gorian, I guess. They group them all together. They shouldn't do that. It's lazy and sloppy. So they group these 3 together, and these three were the Judge Fredman, rotten decision by Judge Fredman, crooked as could be. The rotten decision by Gorian, who never got elected again, I'm happy to say, and the rotten decision by Rosado, who is still on the bench. The cases were against Scott Lord. The other one was against Philip Amicone in the White Plains Building Department and former mayor of White Plains, Del Vecchio, and against CBS. That would be Peter Lund and Joseph Abraziz, and Beth Bresson, and Marty Daly, and Matt Steinfeld, and Matthew Margot. Grouped them all together and said, no, we're not going to give you leave to appeal. Denied the opportunity for leave to appeal. And that's the New York State Court of Appeals for you. I don't know why we have to pay them so much money. I don't know why we have to have them around. The best thing you can say about the New York State Court of Appeals is that their chief judge, Saul Walkler, went to prison. The chief judge of the state of New York went to prison, lest we forget. So let me show you those. Let me gather them. Here's the Conrad Duberstein one. And here's a couple of more. All came on the same day. First the 3 denials came, and then this came, and this is a laugh. Let me just read it to you. You know, a 6-year-old could have done better. Motion for leave to appeal to the Court of Appeals in the above cause, Glendora Appellant versus Conrad Duberstein, Richard O'Connell et al. Having therefore heretofore, let me start again. A motion for leave to appeal to the Court of Appeals in the above cause having heretofore been made upon the part of the appellant herein, and papers having been submitted thereon, and due deliberation having been thereon had, it is ordered that the said motion be, and the same hereby is denied, Donald M. Sherrod, clerk of the court. You tell me where there was any due deliberation. Judges never saw this, probably. What happened is that some clerks figured this out, and some clerk much on a lower scale than Sherrod. Now here's the same thing, spit out by a computer. And this one is for Glendora Appellant versus Philip Amicone. And here is the very same thing. This is how the envelopes look. So don't ever bother with the New York State Court of Appeals. And carry it further. Don't ever bother with the Appellate Division, Second Department. They don't do their work. They're nothing but rubber stamps, and they cost us something like $150,000 a year. The 3 denials came first, and here's what the denials look like. Isn't that terrific? You really have to go to law school for 3 years. You really have to be a judge. No, you just have to know the right people. And then the clerks will do everything else for you. So down to the State of New York Court of Appeals. So I guess effectually Scott Lord is over. You can still keep your eye on him out there in Nassau County. His current address is 300 Hempstead Turnpike, I believe. And I should have his telephone number for you, but he's operating under the name of Forever Green. And Forever Green would apply to the Department of Consumer Affairs of Nassau County and to James E. Picken. Forever Green, who let Scott Lord operate right under their nose, and also to Thomas Galata, with no consumer affairs license, with no protection of you, the consumer. That's what is happening in Nassau County. Thomas Galata and James E. Picken are letting Scott Lord operate Forever Green, an underground, quote-unquote, lawn sprinkler company with no consumer affairs license. So effectually, I say again, Glendora versus Scott Lord is over, except for keeping our eyes on him and on the Department of Consumer Affairs and on the County Executive's Office, except for operating without a home improvement license. The rest of the home improvement contractors have to pay their $100, $200, $300, maybe $1,000 for a home improvement license. But Scott Lord, who's been arrested for this once and was on probation for 3 years and is allowed to let go by Dennis Dillon, still, I think, operates without a consumer affairs license. And I'm sorry that I don't have, the thoughts are all jotted. This is the way you do that, folks. You jot the thoughts when it comes in, because a million thoughts come to you, and you just jot them down there. And the first page of Jot Thoughts is done, typed. And here's some more. And they are that no judge ever signed. There's no signature of a judge on this. The record has been on TV. It will continue on TV. They should close the courts. The courts are out of order. It's a conspiracy between the Westchester Supreme Court and the Appellate Division, 2nd Department, and the New York State Court of Appeals. Sing their theme song, "We're All Connected." I just spent another $100 and 20 hours sending up another motion for leave to appeal to this New York State Court of Appeals. That would be on the Cupola 1 rotten decision and the similar rotten decision of the Appellate Division, 2nd Department. 2 weeks before that, I sent up another one, a motion for leave to appeal on the rotten decision of the Cupola 2, and then again the Appellate Division, 2nd Department. So, and that one cost about $20 to send up, and it took about 10 hours. It seems to me the higher up you go in the New York State court system, the worse it gets. The worse the work is, the more lacking the judgment is, the more like the Three Stooges it is. They are a waste of time. The higher up you go, the harder they fall. And the more hopeless it gets, justice in the state of New York. They give no reason for the decision, because that's because they never even read the papers. They don't even know what the case is. I would love to put those people under discovery. All of them. The judges in the Westchester Supreme Court, the judges in the Appellate Division, the 2nd Department, and the judges in the Court of Appeals. We are stripped of our courts. We have a pile of rubble over here called the Westchester Supreme Court. We have a pile of rubble over here called the Appellate Division, 2nd Department. We have a pile of rubble over here called the Court of Appeals. You might as well get rid of all of them. And we're paying heavy tax money for these people. We're carrying them. Why don't they go out and make an honest living? I write 50 pages, and you see what they return to me? It's not even a full page. And there's no name of a judge. They don't earn their money. They don't even know how to fold a letter. If you're sending out a letter in a number 10 envelope, folks, you fold it 3 times. You have 3 creases. A 3-fold. Okay? What do? They don't know how to do anything. They fold it 4 times, like this. They don't know what they're doing. Okey-doke. That they've sold their souls, they have no souls left, all they have is greed, and so what do? You can't do anything with the courts. The courts are broken down. You have to just go out in the street and rally. You've got to go out in the streets and let everybody know. They're deaf, dumb, and blind to justice. Judiciary is indispensable to justice in our society. Every judge shall participate in establishing, maintaining, and enforcing, and shall himself or herself observe high standards of conduct, so that the integrity and independence of the judiciary may be preserved. The provisions of the part shall be construed and applied to further that objective. And this is the rules governing judicial conduct. A judge shall respect and comply with the law. Did you see any of that here? Have you seen any of that here on television for 4 years? and shall conduct himself or herself at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. Let me ask you something. Do you have any confidence in the judges of the Westchester Supreme Court, the Appellate Division, 2nd Department, and the New York State Court of Appeals? Do you see any integrity there? Do you see any impartiality there? No judge shall allow his or her family, social or other relationships to influence his judicial conduct or judgment. Someday we'll really go into that and read some more of that. Let's do 4th paragraph, and we'll know where to pick up. No judge shall lend the prestige of his or her office to advance the private interests of others, nor shall any judge convey or permit others to convey the impression that they are in a special position to influence him or her. No judge shall testify voluntarily as a character witness. Well, now where have you seen that? Impartiality, independence? No. We're all connected. Yesterday at the White Plains Public Access Studio, I saw colabella, who is the political boss for the Republicans here in Westchester County. And he calls all the shots for the judges, and he makes all of the decisions. First page of the protest going to the New York State Court of Appeal. Glendora protests 3 more decisions by the New York State Court of Appeals to give her justice. Now, how many is that? Well, let's count them. We sent Nikolai up there. We sent Ruskin up there. We sent Donovan up there. We sent Garayan up there. We sent Rosado up there. And we sent Fredman up there. It's 6. Unilaterally. All stuck together. Now, how many have gone up there in addition? Capola 1's gone up there, and Capola 2's gone up there. So that'll give them 8. Seems to me there were 9. What's that leave us? That leaves us Silberman and Wood and Colabella and Ingracia. And it'll be the same thing. It'll be a rubber stamp. Same thing. Glendora just got through announcing on television that it would be 10 weeks, Labor Day, before the New York State Court of Appeals would be deciding on leave to appeal on Amicone CBS Scott O'Connell. That is what Glendora was told, 10 weeks. And the decision came July 4th, 1995 instead. It must be Glendora's rallying and reports on TV that the New York State Court of Appeals could not wait to get out the denials. 1, 2, 3. So how many does that make unilaterally? The New York State Court of Appeals denied Glendora justice on Nikolai, Ruskin, Donovan, Garayan, Rosado, Fredman. 6 in a row. The New York State Court of Appeals does Glendora a lot of good. Quote, "They are so used to not listening," unquote, a friend of Glendora told her. Judge of the New York State Court of Appeals who ended up in federal prison, Saul Wackler. That is what we have to work with. We have 7 computers in black robes. And we pay all this money for these rubber stamps. The Appellate Division, 2nd Department is so bad, and you just rubber stamp the badness. And the New York State Court of Appeals costs the taxpayers all that money. Quote, "after due deliberation," unquote, is a lie. Some clerk hit the button on the computer and got this out. This is button justice, push a button clerk, and it comes out of the computer. The New York State Court of Appeals is a waste of time and money. There is no signature. Nobody signed it. That's the first page. Why does this light wash it out so you can't see it? We'll have to set this set up differently. To you, what has been written, I haven't had time to write it all, just some of it. And why haven't I had time to write it? Because there's so many crooks in the world, and there's so many crooked lawyers in the world, and there's so many corrupt judges in New York State. That's why. This is. They didn't even pay attention to the law. There is no law that you have to have the permission of a bankruptcy judge to sue. Permission of the bankruptcy court to sue Richard O'Connell, trustee. There is no such law. It was a lie from the beginning. I showed the Supreme Court, Westchester County, that was a lie. And they ruled on something that isn't a law. There is no such law. I showed that to them. And the Appellate Division did the same thing. They don't even have laws to rule things on. And we just read in the Code for Judicial Conduct that they're upholding the law. They have no law to uphold that with. And so along comes the Court of Appeals, 7 justices so-called, and they do the same thing. They don't keep the law. Shouldn't a judge keep the law? That's the worst thing of the whole thing, is that you don't have judges who obey the law. From the computer cough-ups of the New York State Court of Appeals to the Corruption Chronicle. This was sent to me by Harvey Cass and Carl Lancezera, and it's excellent in the sense that it exposes things that you already know about crooked lawyers. The American Bar Association. To many Americans who have dealt with lawyers, the letters ABA means awful bad attorneys, or awful bad actors, or awful bad associates, or awful bad association. Yes, sad to say, the word bad, B-A-D, comes to the minds of many Americans when the American Bar Association is mentioned. Yes, bad, bad, bad to the 3rd degree. What are you lawyers going to discuss at your annual meeting of the ABA this year? Are you lawyers going to discuss how to keep your monopoly on the practice of law while 243 million American citizens, 90%, are being denied adequate, effective, meaningful, and honest access to the courts? Are you lawyers going to discuss how you can keep your profits flowing as you butcher families in your divorce courts and as you eat up, prey upon, like buzzards, the economically sick and dead in your bankruptcy courts? Are you lawyers going to discuss the fact that if the deputy sheriffs and metal detectors were taken away from the courthouses, that the courts would shut down in many jurisdictions across America? Are you lawyers going to discuss how to keep non-lawyers from helping fellow Americans in need of legal help? Are you lawyers going to discuss how to keep the hated pro se litigants from representing themselves in court? With the judge's help, of course. Will you lawyers even mention the words integrity, righteousness, and justice during your entire annual convention? Will you lawyers discuss the fact that you must put integrity, righteousness, and justice foremost in your minds and hearts in order to regain the confidence, trust, and respect of the public? Remember, integrity, righteousness, and justice. Thanks to honorable judges and lawyers, we here at the Florida Foundation to Fight Corruption express our thanks and sincere appreciation to the honorable judges and lawyers who are honest and who are walking in the way of integrity. We fully support you, and we urge you to take very aggressive action and fulfill your duty by reporting any and all judges and lawyers who commit unprofessional conduct or criminal acts. We the people, quote unquote, are demanding that corrupt judges and lawyers be cleaned out and removed from our judicial system. All our readers can totally trust the Corruption Chronicles to protect your identity in total confidence. If any reader wishes to contact us, it should be on how, where, and to whom corruption should be reported. Okay. Corruption Chronicle. Page 4. Job description for judges. The English common law and our American system of jurisprudence, United States Code, all have their roots in the Mosaic Law Code, as recorded in the Holy Bible. A job description for judges is clearly and simply set out in the Holy Bible at Deuteronomy chapter 16, verses 19 and 20, which states, "You must not pervert judgment. You must not be partial or accept a bribe, for the bribe blinds the eyes of wise ones and distorts the words of righteous ones. Justice, justice you should pursue." This job description is quoted from the New World Translation of the Holy Bible, and these instructions, as given by the chief judge of all the universe, Jehovah God, are binding upon the judges and lawyers who are privileged to serve as officers of the court, quote unquote, in our society today. These words, those requirements, are very clear and simple. You must not pervert judgment. You must not be partial. You must not accept a bribe. Justice, justice you should pursue. Do you hear that? Nikolai, Ruskin, Donovan, Urian, Fredman, Coppola, Colabella, Silverman, Wood, and Ingracia. To all our supports, we appreciate and thank you for your support of freedom and justice. We encourage you to fully obey the law and to fully support our law enforcement officers. We encourage you to support honorable judges and lawyers, to report corrupt judges and lawyers, to hate what is bad and to love what is good. Donations. We sincerely thank our supporters for the monetary donations that you have sent to the Florida Foundation to Fight Corruption and the Corruption Chronicles. Because of your monetary donations, we no longer charge for a subscription to the Corruption Chronicles. The Corruption Chronicles will be mailed free of charge to any person who desires to receive it. Please be assured that your donations will be used in furthering the work being done by the Florida Foundation to Fight Corruption and the Corruption Chronicles. Please contact us if you are willing to distribute the Corruption Chronicles in your area, and we will supply you with as many extra copies of each issue as you request. We send you our very warmest regards. The Corruption Chronicles. P.S. The administration of justice is the most important business of the state. Cone versus Cone. 68 Southern 2nd, 886. Now, I suggest that you go through Harvey Cash and Carl Ancesara, and they're running the Americans for Legal Reform, the Nassau County chapter. And I suggest you go through them, and that's their telephone number there on the screen. Welcome everybody to a chat with Glendora, and this is program number 1808. And this program is about the law breaking of Cablevision and its management, whose names you see on the screen. And first we're going to have our jokes, and Diane says, I have the most wonderful recipe for casserole. And Marilyn says, tell me about it. Diane says, I simply mention it. My husband says, let's eat out. The lady said to the artist, oh, your colors are so beautiful. I wish I could take some home with me. And the artist says, oh, you will, ma'am. You're sitting on my brushes. And the little Hollywood extra, he finally got a speaking part in a movie. All these years he'd just been an extra, and then he got a speaking part in the movie. And the scene was the district attorney was to say to him, did you see this woman drink a cup of coffee? This cup of coffee. And then the little extra was supposed to say, I did. So he went home and he rehearsed all the different ways he could say I did. He said, I did. I did. I did. And it came time to shoot the scene. And the district attorney said, did you see this woman drink this cup of coffee? And the little extra said, did I? Now, we tell you that these logs, which were all backed up, Glendora TV log, finally got out the week of, wait, there's one more, folks. The week of June the 19th. Right here. I gave Franco a going away present, and then we had sort of a going away party. I hate to have Franco leave me. And we finished program 1799. We did 1800, 1801, 1802, and 1803, some of it. Oh no, we did all of that. And then 1804, we did about 18 minutes of it. And I have to learn how to press the edit button and the color bars, and have to bring it on preview and how to put it on the videotape. And then I have to learn the patching of the video out into, and the patching of the audio out into. And I learned how to make a VHS and an 8mm archive and a VHS copy for those TV stations that don't take 3/4 inch. And then I learned how to make the big one, which is the 3/4 inch one. And so that's going on now. Maybe he'll be with me a couple of weeks, maybe less. But it'll be a sad day when Franco DeRose leaves. We got the tapes ready to take to a Manhattan cable television. The lawyer says, I want a new trial on the basis of new evidence. The judge says, what's new evidence? And the lawyer says, I just found out my client has another $3,000. There was a mix-up at White Plains Cable Television for the first time. Half of the mix-up was my fault. For legal reform in Nassau County was interviewed by the New York Law Journal, and he mentioned Glendora's name, and he asked Glendora to call them. And Elena and Dan picketed in Nassau County. They went to the meeting of Americans for Legal Reform. Elena and Dan are from the Center for Judicial Accountability here in White Plains. They went all the way down to Nassau to go to the meeting of the Americans for Legal Reform, and Carl invited them as guests to stay over in his home. And in the morning they went out and picketed in the Nassau County Supreme Court. And I guess they were pretty impressed by the whole thing. Now that's something that I want to do, but of course I can't free up the time for that. Picketing in Nassau County and Suffolk County is so much easier because everything is above ground. All the parking is above ground. Here in Westchester, all of the parking is underground. So, but we will have to picket just the same, no matter what the difficulties are. I watched Hyacinth, which is Keeping Up Appearances, on Channel 20 and 21 on both Friday and Saturday nights. Saturday was 17.5 hours on a notice of motion and protest to the New York State Court of Appeals about the rotten decisions of Judge Matthew F. Coppola, the first one and the second one. And there it is, 17.25 hours, $110. And all he spent was 2 minutes, not even reading it, just signing his name. Rotten judges. Rotten work. We went to church on Sunday. I'm dressed in red, white, and blue in celebration of 4th of July, but I have a little purple on me because that's the communion grape juice. And we took care of the bird bath for the minister's wife. We're going to do that all summer long. Every 2 days we will change the bird bath. We had punch and cookies at church. And the minister's gone away to loaf for 2 months. All in all, he loafs about 3 months in a year. The stats on Cablevision, we finally got them added up for the week of June the 19th. We spent 11.25 hours on the law breaking of Cablevision and $11.34. For the week of June the 26th, we spent 5.25 hours on Cablevision, and we spent $3.20. 3rd, 1995, Monday, day before 4th of July. It's a bad thing to be fighting a head cold with coughing and sneezing and hacking. Those miserable viruses are worse than the judges in the New York Supreme Courts. Franklin did the end of the week, he did the end of the month finances, and of course the end of the second quarter, and of course the end of the half year. That's an amazing accomplishment. He should have taken a week to do it, but he did it in a quarter of a day on July 4th. The backpack with all of the accessories, when you handle them so many times, like a library, it picks up an odor. So threw away all of the plastic bags, got out all new bags, and of course you can't wash the connectors and the junction boxes and the AC converters and all that. You can't wash all that high-tech equipment. So I put it in the windowsill and let the sun air it all out, and then washed the backpack, and now everything's sweet and clean. To sit out in the woods, in the property contiguous to this property, sit out there in a chair under the trees is a great, wonderful gift. And we thank you, God. 5:30 a.m. to 6:30 a.m. I got all backed up in 9 days because of so many lawbreakers, crooked lawyers, and corrupt judges. So it took about 4 or 5 hours to bring those up to date. And finally, after 2.5 weeks of letting it go, we got time to clean the house, and we got time to wash the poor car that had to be pushed aside because of the lawbreakers, crooked lawyers, and corrupt judges. Watched Nanny Monday night, and finally by 4th of July at 6 p.m. We got the work done, and we actually could sit. And we went up and did the bird bath again and sat there on that beautiful lawn. It must be 200 feet, maybe 150 feet wide and about 100 feet deep. And all the Saturday jobs and Sunday jobs were finished by July 4th at 6 p.m. One other thing to tell you, I couldn't go to the Folsoms. We were going to have a 4th of July dessert at 3 o'clock, and I couldn't go because of this cold. And I wouldn't want to give this cold to anybody, particularly 2 people who are 93 years old. A lot of people request the Glendora Happy Book, and we keep up with that and keep them sent out and up to date. At church we had punch and cookies. And at 9 p.m. a chat with Glendora was on TCI, which goes to 21 towns in Westchester. And the doctor says, your cough is much better today. And the patient said it should be. I stayed up all night rehearsing for it. The 1980 Lincoln, which has gone 205,000 miles, was running rather roughly, and I diagnosed it as it needed transmission fluid. And sure enough, when the transmission fluid was put in, you can't even hear it. You can't even feel it. The ride, I mean. You hear no noise, and you just don't feel any vibrations. Just as smooth as it could be. I called the Pace Law Library, and Professor Triffin answered, and I told him what I wanted in advance to see if they could get their act together for once. And when we got there last night, Wednesday night, around 5:30 or 6:30 or 7, they did have it all in order. They had the microfiche, portable microfiche set up on the desk. They won't let anybody in from the public. It's really a terrible thing, and I'll address that later in our Westchester County program. But this is Nassau County, and you don't want to hear how greedy and corrupt the Pace Law Library is. And so that's the Glendora versus the names that you see on the screen, the logs from June the 29th to today, July the 5th, 6th. I want to read you this brilliant letter by Brian Grafman to Judge Bryant. And when I do that, the microphone pops out of the little holder, the little lapel. Get in, but it's a cute little thing. Okay, we hope we didn't break a wire. K-Room Grafman, 1370 Avenue of the Americas, 32nd floor, New York, New York, 10019. Chase A. Carroll and Brian D. Grafman, and Mark Babylonia, and Taryn Hart, and Eva Pasavino. Honorable Charles L. Bryant, June the 29th, 1995, United States District Judge, United States Courthouse, 300 Quaropa Street. Quaropas, you know, means White Plains. White Plains, New York, 10601, Glendora versus Cablevision et al. Index number 93 Civ 8344. Dear Judge Bryant, I am co-counsel for Media Access, New York, Manny. In the above action, I submit this letter to supplement Robert T. Perry's June the 14th, 1995 letter to you regarding the public forum theory in light of the recent decision in Alliance for Community Media versus the FCC, 1995. In his letter, Mr. Perry notes our recollection that Judge Minor had remarked that public access channels were a public forum and that we had requested a tape of the argument to verify that recollection. We now have that tape. Recognizing that remarks at oral argument are not necessarily indicative of a judge's considered view, we think Judge Minor's remarks strongly indicate a view that, at the least, the issue of public forum is one of the substance. The following are excerpts of Judge Minor's remarks. You remember these. We told these to you. Here, the government itself has required that these channels be open to the public and has provided that if the government wished, it could administer and operate these channels, these access channels. It has delegated that operation to the cable system, and you are clothed with a public interest. You, Cablevision, Charles Dolan, John Tata, William Quinn, William Bell, and the rest of you are clothed with the public interest. I understand regulation alone doesn't convert you into state actors. For example, the regular airwaves are very highly regulated, and what a regular television station or radio station does is not state action. I am suggesting the situation is a little more delicate here with these public access channels that have been created by Congress and by the state legislature. Don't you see the difference here that makes it a little closer case? It's because they can step in and regulate and administer and so forth. But they haven't. They're allowed you to do that. They've allowed you to do that. Congress has allowed you, state cable TV companies, to do that. You, Cablevision, Congress has allowed to do that. So they've allowed you, in effect, to be the government in providing this access. It's not a traditional public forum. My only concern is whether it's a limited public forum. Well, you don't know too much about it, but Congress and the legislature seems to know a lot about it. And they say let everybody in there. Now they mean public access. Access by the whole public and without any censorship. That's what Minor said at the oral argument, September the 20th, 1994, at Foley Square. You remember that. I reported it to you. Respectfully submitted, Brian D. Grafman. 5636, he has a number. Copy to Robert M. Kalaji, and Glendora, and Robert T. Perry. Very well done. That kid is brilliant. Brian Grafman. He enclosed with it the mess that the Gannett newspapers made of a public access article, so-called, which I will read to you some of it later. They did not interview me. They did not interview anybody I know, except maybe Fred Strauss. Oh yes, and the young man over in Mount Vernon who's so nice. We don't put a chat with Glendora on TV in Mount Vernon. We did have it on there, and then the Mount Vernon cable access operation went all to pieces a couple of years ago when they got shafted by teleprompter, when the city of Mount Vernon got shafted by teleprompter. And then we never really had the time to pick it up and resume with them. We have here a motion of mine to the Honorable Charles L. Bryant, United States Judge, United States District Court, 300 Quaropas Quaropus, remember, was the Indian term for White Plains. They stood down where, well, where the Westchester Mall is now. It used to be, what was that store? It wasn't Abraham and Strauss, but B. Altman, where B. Altman used to be. And they would stand there in the morning and they'd see all of this mist, because you know White Plains is a swamp. And they'd see all of this mist rising in the morning. And that's what they said. Quaropus, White Plains. The sheriff of Westchester County, this is all connected with Cablevision because the sheriff of Westchester County cheated me out of collecting the money, my costs that Cablevision owes me, and I was certainly legally due those. And then it was Judge Silverman, of course, who robbed me of my costs. Not just once, but twice. And the sheriff of Westchester County was in collusion with Judge Silverman. And the county attorney was, the Westchester County attorney was in collusion. They were all so happy that they had a reason not to, a faked reason, not to go out and collect my costs as they should have. And so I've had 3 complaints about the Westchester County Sheriff, and this is number 4. And I said that last week, there goes the microphone, I said that last week I would show you this report. It is so silly. This investigation, what a waste of taxpayer money. The Westchester County Sheriff, his name is Culinary, and we've got to do something about moving the desk closer to the camera so you can read the papers and see them yourself. Anyway, says the investigation into the allegations contained in civilian complaint report so-and-so number, meaningless, filed by you with this department have been concluded. The findings are as follows. Allegation, neglect of duty, unfounded. And I read you my criticism of that. Please regard the enclosed missive. This goes to Commissioner Culinary, who's the Sheriff of Westchester County, County Executive Andrew O'Rourke, County Attorney Robert Villani, the Assistant Robert Villani, and Sheriff's Office Bill Ryan, County Police Officer Richard Johnson, Sheriff's Office, same office, James Eakley, who never collects in Portchester, Glendora's TV audience, that's you, and to anybody else of interest, and to Judge John Silverman. This was delivered by hand to all of those people above except Culinary, which was sent by United States Mail. Please regard the enclosed missive. What do you think of it? You conclude that it is not just that Richard Johnson and James Eakley and Robert Villani who are bad. It is the whole department. No reason is given. There are no grounds. There is no substantiation. There is no evidence. There is no report. But there was a report on TV about it. The record was that much worsened. At the bottom of this letter is law enforcement agency. This is not a law enforcement agency. They do not enforce the law. The Sheriff's Department has never done their job. Not with Cablevision in 1991, not with Estavas in 1992, not with Brower in 1994, and not with Gallicano in 1994. Then we have collusion with the county attorney and with the judge. What is your motivation to be so bad? Oh, and tell me this, Glendora was in the county clerk's office, the 3rd floor, the low-rise building, the 2nd office on the right after you turn the corner, June 23rd, 1995, Friday at 9 a.m. A good-looking black man in his mid-20s was taking $5 from an older white-haired white man. Quote, what number do you want? Unquote. 17, quote, unquote. The white-haired man said. Okay, the young man said, I'll put you down for the Phillies. Glendora said to both of them, gambling, a lotto, in the county clerk's office in broad daylight? The young man says, oh, it's not gambling, it's just a game, and he hastily went off, deeper into the office. Where is the county sheriff on that matter? Where is the county sheriff on that matter? Commissioner Culinary. Where are you at that time? Back to the letter Glendora received on June the 21st, 1995, Wednesday, the summer solstice. You never did answer my question. Do you get paid, or do you get gifts or perks from the people you don't collect from? Did you inform Silverman that he had not signed the order? Silverman was 2 weeks late signing the order in violation of CPLR 2219. A judge has 60 days to decide a motion. And Richard held the order jubilantly in the air and said to Franklin, "It's signed! It's signed!" But he would not let Franklin see it or copy it. "Bring back Anthony Mosca. Did you see your sergeant's belly in the Gannett paper when we rallied? Your number 12, belly bully? He thought we did not know our rights. We had our permit to rally. He tried every fake he could think of to scare us away." Let me show you that picture again, folks, as long as we're talking about it. This is the big belly sheriff, number 12. You also saw him on videotape. You see the picture? What do you see? A belly. Well, his record of same was on TV also. This so-called investigation, quote unquote, was puerile and a waste of taxpayer money. It was a poor performance, like your refusal to collect and do your job. And there's no joke of the day for you. Yours in truth, Glendora. This is a notice of motion and an affidavit in support of, to the United States District Court, Southern District of New York, Glendora, plaintiff appellant against Cablevision Systems Corporation, Charles F. Dolan, William J. Bell, Mark A. Lusgarten, Francis F. Randolph, Jr., John Tata, James A. Colfault, Joseph Osnara, Thomas Garger, and William Quinn, defendants appellees. Please take notice that upon the attached affidavit of Glendora sworn to July 3rd, 1995, and upon all prior proceedings head herein, plaintiff appellant Glendora will move this court at 300 Quaropa Street, White Plains, New York, 10601, on the 13th day of July, 1995, or as soon thereafter as plaintiff appellant may be heard, for an order compelling discovery, as plaintiff appellant has demanded pursuant to Federal Rules of Civil Procedures 26, 30, 33, 34, and 36, dated White Plains, New York, July 3rd, 1995. Yours in truth, Glendora. Chat with Glendora and to Robert M. Kalaji. Glendora, being duly sworn, deposes and says her reasons follow for moving this court for leave to file a motion. As attached, it is the law. Federal Rules of Civil Procedure, Rules 26, 30, 33, 34, and 36. Defendants have violated the law. That's the defendants whose names you see on the screen. Defendants should be sanctioned. Judge Bryant told Glendora on March 3rd, 1995 to start discovery as soon as she filed her amended complaint, and the sooner the better, quote unquote, Judge Bryant said. Glendora's amended complaint was filed March the 20th, 1995. Discovery is necessary. Plaintiff was deprived of discovery in state court in April, May, June, and July 1994, and in federal court in February, March, April, May of 1994. Plaintiff wants discovery. Defendants are fugitives from discovery. They are committing fraud upon the court. Fugitive defendants cause Glendora the labor and time to change the dates discovery is due. Interrogatories, delete May the 30th, insert July the 21st. Documents, delete May the 31st, insert July the 24th. Inspection, July the 31st, 1995, 2:30 p.m., keep it there. Admissions, July the 3rd, 1995, delete, insert July the 21st, 1995. Oral deposition, July the 10th, 1995, delete, insert July the 28th, 1995. Dated White Plains, New York, July 3rd, 1995. Yours in truth, Glendora. Chat with Glendora. And it's notarized by Francis Harrison in the county clerk's office. And that brings us up to Cablevision annual report. We find out where we left off the last time I was reading it to you, and we'll read about 10 pages. This is going to go on for quite a while, every week. The annual report is this fat, and I'm this fat too, 165 pounds. The annual report says that cable television program distributors such as Rainbow Programming are not regulated by the FCC under the Communications Act of 1934, but under the Communications Act of 1984, and of the 1992 one, they are diversify. Diversify, no monopoly. The 1984 Cable Act prohibits localities from requiring carriage of specific programming services. Satellite common carriers, from whom Rainbow Programming and its affiliates obtain transponder channel time to distribute their programming, are directly regulated by the FCC. the World Administrative Radio Conference. And inflation. The effects of inflation on the company's costs have generally been offset by increases in subscribers' rates. Revenue. $666 million in 1993. Fade to black. Now, folks, we're going to read to you from the Cablevision annual report. We're going to jot some notes here. The revenues increased in 1993, rather 94, $94 million. Selling, general, and administrative expenses increased $52 million. Technical expenses for 93 increased $37 million. Remember, they own U.S. Cable. Don't forget that. When you see U.S. Cable, remember it's owned by Cablevision. We're up to page 45 of the annual report. They have this thing called the restricted group. That's Cablevision Systems Corporation, your company, and some other ones. And they are subject, the cable systems located in New York State that are owned by the restricted group and VC Holding are subject to agreements, the New York upgrade agreements with the New York State Commission on Cable TV. Under the City of New York City, CNY, Cablevision of New York City, CNYC, purchase agreement, the restricted group has guaranteed certain payments to Charles F. Dolan, the chairman and chief executive officer of the company, consisting of an annual payment of $5.6 million. A $40 million minimum payment, and a preferred payment not to exceed $150 million based upon an appraised value of Cablevision of New York City. Oh yeah, and then they don't pay Glendora her costs for winning the lawsuit against them of $1,000. Now we have quite a few, they don't pay any dividends on common stock, A or B, but on the other ones they pay dividends. Well, V is in victory, or V is in something else, a virus. It would be unable to meet certain of its financial covenants during 1995. They have Monmouth and Riverview, which I believe are in New Jersey, they don't say. And they have arrangement with Toronto Dominion, Texas, and as I read you in the directors, they have a big connection. That's one of their friends. On March 10th, 1995, MSG Holdings, a partnership between a subsidiary On March 10, 1995, MSG Holdings, a partnership between a subsidiary of Rainbow Programming and a subsidiary of ITT Corporation, a Delaware corporation. ITT acquired Madison Square Garden Corporation in a transaction in which MSG merged with and into Holdings. The purchase price paid by Holdings for MSG was $1.1 billion. In connection with obtaining the consent of the National Hockey League and the National Basketball Association of the indirect transfers of the New York Rangers and the New York Knickerbockers, respectively resulting from the merger, the company and Rainbow Programming entered into agreements with the National Hockey League and the National Basketball Association, agreeing, among other things, to conduct themselves in accordance with the relevant rules of each league. Thank heavens the hockey season is over. The Devils won in hockey just the way they do in the courts. Pursuant to an agreement between Rainbow Programming and National Broadcasting Company, NBC may require Rainbow Programming by notice given on or before April 13, 1995, and that's over, to purchase its interest in Sports Channel New York and Rainbow News 12 Company for an aggregate purchase price would amount to approximately $93 million. Assets. Cash and cash equivalents, $11,350,000, and they can't pay Glendora $1,000 costs. Now, independent auditors report. It says, in our opinion, the consolidated financial statements referred to above present fairly in all material respects the financial position of Cable Systems Corporation and subsidiaries at December 31st, 1994. Of course, the independent auditors Pete Marwick, KPMG, Pete Marwick, Jericho, New York, are going to say that because they want the job next year. So total assets, folks, I got to just come right over there and show you that. I'm going to bring the microphone with me, and we're just going to walk right over there because you got to see it. There we are. The total assets are 2.2 billion. I thought it was 2.5 billion. Nah. That's a few billion one way or the other, right? So now we've got the annual report read to you. Liabilities and stockholders deficiency. I say that's management's deficiency, not stockholders deficiency. And no dividends if it's Class A or Class B, but the other guys, the guys whose names you see on the screen, they get dividends. They have feature film inventory, and they have, now listen to this, subscriber lists are amortized on the straight line basis over varying periods. You see, you are their assets. You're a subscriber. Subscriber lists are amortized on the straight line basis over varying periods, 4 to 8 years, during which subscribers are expected to remain connected to the system. They're taking you for granted. Franchise are amortized on the straight line basis over the average remaining term, 7 to 11 years of the franchises at the time of acquisition. So they're taking you municipalities for granted. We have mentioned, small mention here of Cablevision of Connecticut. Cash flows, loss per share, income taxes, acquisitions, restructurings, and dispositions. North Coast Cable, where is that? And we have Cleveland Cable, and AR Cable, that's the one you have in Harrison and Port Chester, and Yonkers, and Yorktown, American Movie Classics Company, Rainbow Programming. A wholly owned subsidiary is MFR, Monmouth Cablevision, Riverview Cablevision, Framingham Cablevision, that's in Massachusetts near Boston, where I was stuck in a flood. when I was on TV for the Milton Bradley Company on WBZ-TV, Boston, Channel 4, the Westinghouse station, and I hear little Ginny Cat. The company purchased the business of CATV Enterprises Incorporated in Riverdale in the Bronx, finally. That cable system was started by Fred Fenley. Remember Fred Fenley? He was the head of news for CBS. And you remember his son Andy Friendly over at CNBC who double-crossed me? And then it was bought by Westinghouse. It's up in the Bronx, that cable system, one of the very earliest. Goes way, way, way back. 60s, 70s, 1960s, 1970s. Prior to the Cablevision New York City acquisition, the company had a 15% interest in Cablevision New York City, and Charles F. Dolan, the chief executive officer and principal shareholder of the company, owned the remaining interests. Now, Mr. Dolan's preferential rights entitle him to an annual cash payment of 14% multiplied by the outstanding balance of his minimum payment. The minimum payment is $40,000. Or is it 40,000? It says dollars and thousands. No, it must be millions. The minimum payment is $40 million and is to be paid to Mr. Dolan prior to any distributions to partner to other than Mr. Dolan. In addition, Mr. Dolan has the right exercisable beginning December 31st, 1997, to require the company to purchase his interest. Mr. Dolan would be entitled to receive from the company the minimum payment, any accrued but unpaid annual payments, a guaranteed return on certain of his investments in Cablevision New York City, and a preferred payment defined as a payment not exceeding $150 million, equal to 40% of the appraised equity value as defined, you know what all this understands, of Cablevision New York City after making certain deductions. Now we have another one down here. Let's see if we can find where the sentence starts. Based upon estimates for accounting purposes of the appraised equity value of Cablevision New York City made by the company at December 31st, 1994, approximately $101 million, is it? $22 million and $27 million respectively, 1994, 93, 93, was accrued as additional obligations to Mr. Dolan relating to the company's purchase of Cablevision New York City, which have also been charged to par value in excess of capital contributed. See, this stuff is so convoluted and so involved that it's beyond your ability to understand it. Now we have AR cable here, and included in share of affiliates net loss in the accompanying consolidated statements of operations for the years ended December 31st, 94, and then they put these all in one sentence, 94, 93, 92, 91. The net losses, I think it's something like 67 million, 56 million, and 30 million. And we have here pro forma results of operations. You know who pro forma is. He's Charles Former's brother. And after May the 11th, 1997, either Warburg Pincus or the company may irrevocably cause the sale of AR cable, subject to certain conditions. That means that Cablevision could lose Yonkers, Yorktown, and Harrison, Port Chester. Land and land improvements, property, plant, and equipment. I guess it's $1.5 billion, and less accumulated depreciation and amortization, and I guess that's $886 million. And for financing purposes, Cablevision Systems Corporation and certain of its subsidiaries are collectively referred to as the restricted group. On October 14, 1994, the restricted group entered into new $1.5 billion credit facilities with a group of banks led by their friend Toronto Dominion Texas as agent. And so you're up to date. This is as far as I've read, up to page 71. Just the Series E preferred stock got a dividend of $1,000 per share. But the AB stock We didn't get any dividends. The company paid cash dividends on the Series E preferred stock during 1994, approximately $5,500. I told you the reason that we don't get dividends is because the money goes to the management and to the lawyers. What do you call a miniature guppy? You give up? What do you call a miniature guppy? A microfiche. And you heard about the bunny rabbit who wanted to be changed into a goon within the next 24 hours? Why? Why did the bunny rabbit want to be changed into a goon within the next 24 hours? So he could be hare today and goon tomorrow. And you hear about Joseph, who was worried about his fourth daughter getting married, and his friend says, why? And Joseph says, well, you know, my first daughter married a man from Singleton, Missouri, and they had one child. My second daughter married a man from Twin Oaks, Michigan, and they had 2 children. And my third daughter married a man from Three Rivers, New Hampshire, and they had 3 children. And Peter says, so why are you worried about your fourth daughter? And Joseph says, well, she's going with a man from the Thousand Islands. There are 2 things to bring you up to date on the law-breaking of Gannett and Curley and the Corkindale and Watson and Sherlock and Paulson. One is the story that was, or the picture about the rally that was in the Reporter-Dispatch here in White Plains. It was, as usual, a 50% story. The rally was 50% in support of reinstate Doris Sassower. The rally was 50% against all bad judges in the Westchester County Supreme Court. So as usual, and as I've told you always before when I lived in Harrison, Gannett never printed half of the news, even. They left out half of the news. And so with this story, they left out half of that. And there is a protest in progress here to Gannett about that. Regard the evidence enclosed. As usual, you did your half story. The rally was just 50% about reinstate Doris Sassower. It was 50% protesting the bad judges in the Westchester Supreme Court building. Glendora got the permits from the county of Westchester and from the city of White Plains, and the 3rd permit for the bullhorn. These are the judges who are afraid to rule against Gannett. So we say down with Burroughs, down with Nicolai, and see the rest of Glendora's excuse me, chant that is enclosed. This letter, of course, if I send it to Gannett, they will not print it in letters to the editor because Gannett, number 1, won't print anything bad about itself, and then number 2, they won't print anything that Glendora writes. And the other thing is the Gordon Burroughs decision, Charles Devlin decision, which is just as crooked as their first decision, saying that Gannett did not commit libel when they did commit libel. Gannett broke the law, Gordon Burroughs broke the law, and Charles Devlin broke the law. And that's that sloppy decision that I showed you last week. Read you my protest to the same. Here is the protest to Gordon Burroughs and Charles Devlin. It was read to you from the Jot Thought Sheet, and now we will read it as it went out. And I have to get up every time to show you this because the camera's too far away from the set. But I got to show you the this piece of work that Burroughs put out. How's that look to you? Does that look Supreme Court to you? Isn't that a lovely piece of paper? Okay, Gordon Burroughs, haven't you hurt Glendora enough? You have a mean spirit. At the end of your life, you have a mean spirit. You did not have to award costs in the first place in 1992. That was dead wrong. Then in your veniality, you award costs again. There is no need of that, and you will find out one day there was no need of that. Here Glendora is abused by Silverman and Kalaji, robbing her of her costs. When she wins the Cablevision case of law-breaking, she pleads you to help her. What do? You turn the knife in the wound. And where did you get the knife? Out of Glendora's back. Franklin and Glendora have lost all their respect for you. We go back to the streets, down with backstabber Burroughs. And you used to be our friend. You bought me a Coke back in 1982 when you were my assemblyman and I lived in Scarsdale. That's Coke, Coca-Cola. As ye sow, so shall ye reap. Except you don't go to church enough to learn that. Glendora spends 30 hours writing you that paper and is up all night, several nights. And what did you spend? 30 seconds. And look at the slop you hand in. Glendora showed it on TV. What is supreme about this? And Glendora will read this TV. On TV. See it in your hometown in Yonkers. A person can trust the undertaker. He's the last person in the world to let you down. But a Westchester Supreme Court judge is the first. Your honor is your dishonor. JSC stands for justice so called. We are stripped of our courts. We have no place to go. The school books lied to us. It was judges like you who made them liars. Nothing remains but rubble. A pile of rubble is to the left that used to be the Westchester Supreme Court. A pile of rubble is to the right that used to be the Appellate Division 2nd Department. And in the middle is another pile of rubble, what used to be the New York State Court of Appeals. Yours in truth, Glendora. June the 19th, it spent an hour on Gannett law breaking. The cost was $0. But on the week of June the 26th, we spent 5 hours. The cost was $4. So we're giving up on the courts. Just go out on the street and rally until they clean out these bad judges. Folks, there's a park in Buffalo named Humboldt Park. Humboldt. And the mother said to her youngster, "What did you learn in Sunday school this morning?" And the little boy says, "I learned that Jesus sneaked through Humboldt Park." And the mother said, well, she called up the Sunday school teacher and she asked, "What did the children learn in Sunday school this morning?" And the teacher said, "I told them that Jesus had a meek and humble heart." The little girl ran into a house and she says, "Grandma, Grandma, I dropped my lunch bag on the driveway and Dad backed the car over it." And Grandma says, "That's Wheels on Meals." And it was a very foggy night and Peter didn't know the road very well. And he was scared to death that he was going to drive into the ditch. And so up ahead, all of a sudden, a car came in, and with bright red taillights. And Peter says, "Oh, he probably knows the road. I'll follow him. That'll keep me out of the ditch." And he followed his car for a long, long, long time. And finally, the car up front stopped, and Peter hit it. And Peter jumped out, and he said to the driver up front, he says, "What'd you stop so suddenly for? Couldn't you have given me a signal?" And the driver up front says, "What? In my own garage?" I've telephoned around to the DHCR in White Plains, the DHCR in Manhattan, and the DHCR in Queens, and the DHCR in the Bronx. Oh, the DHCR, that's the New York State Division of Housing and Community Renewal. And I found out that a lot of the people whom I sued for negligence, my defendants, have been fired. That's good. Cuomo's been fired. Aponte was fired. Ayala was fired. Fernandez was fired. Myron Holtz left, I guess. And so that's good, because I guess in the long run I won. Also, I won in this respect, that when we made a complaint to the DHCR about a landlord complaint, we got an answer within a month from the landlord, too. And so we have to get our answer in within 10 days. So I think I won in that respect. Because when I filed the complaint in 1991, it took 9 months. Now, we got out the motion, as I read to you last week, for leave to appeal to the New York State Court of Appeals on the rotten decision of Matthew F. Coppola, his first one and his second one, and then the rotten decisions of the Appellate Division second department. We got those out to the New York State Court of Appeals. It was a tremendous effort. It was something like 20 hours. The whole day Saturday was ruined by it. You know, instead of doing fun things, we had to do the work of Matthew Coppola, which took him maybe 30 seconds to sign a rotten, lousy decision. And it costs something like $100. It wears out our copying machine, it wears out our typewriter, it wears out our car, it wears us out, just because a judge cannot enforce the law. Instead of just because a judge, namely Matthew F. Coppola, has to be crooked. So, giving up on the courts, there's nothing you can do except go out on the streets and rally. Here is a copy of the protest that went out against the injustice of Judge Nicholas Colabella of June the 28th, 1995, Wednesday. Pages, and this is the reduced version to cut down on the printing costs and the postage costs. So-called Supreme Court, State of New York, Appellate Glendora plaintiff against Elizabeth Hubbard, Alan Beck, Michelle Mayapath, and the Fund for Modern Courts. And this is what happened in Judge Colabella's courtroom on June the 28th, 1995, Wednesday, from 11:10 a.m. in the morning, folks, to 12:35 p.m. Some recollections. The hearing was scheduled for 11 a.m. There were about 10 people in the courtroom. Glendora waited outside with her friends, Linda M. and Carol G. G helped Carol with the format of an appellant's brief for the Second Circuit, the United States Court of Appeals. Glendora showed Carol her brief, Cablevision, which was a winning brief. 10 minutes went by as the courtroom was locked. Maybe the Judge Colabella had to go to the little boys' room. At 11:10 a.m. we were called. Glendora sat at the plaintiff table. Purvis sat at the defendant's table. Colabella says this case was set down for a hearing, de novo, application for attorney's fees. It was heard by me, but with short notice to Glendora. I was trying to fit it into my criminal schedule. Glendora should have an opportunity to cross-examine the attorney and to put her own case. The only purpose of this case is attorney's fees. Well, this threw Glendora all off because Glendora has reasons why her case is not frivolous. This is how her argument was written. The logic is that if Glendora's case is not frivolous, and it is not, and if Glendora has new evidence to show defendants committed fraud upon the court, then attorney's fees, costs, and disbursements and stenographer fees cannot be rewarded. It seems that this has to be dealt with first before any argument about attorney's fees to see if attorney's fees are allowed. Linda asked to come up to the plaintiff table so that she could sit down and hear better, to take her notes. At 11:11 a.m., Purvis was told to take the witness chair. 11:11 a.m. is a magic minute. Thomas Mallon put him under oath. It was good to hear God. Purvis had to be reminded to put left hand on Bible and raise the right hand. He had it backwards. Cola said to Mallon, "Tell him to sit." Purvis, application for counsel fees back in the summer of 1993. Glendora volunteer. No, it was in the fall of 1992. In November I got a call from Elizabeth Hubbard that this lawsuit filed in November 93. Remember, Glendora tried to get Hubbard to settle before this dispute went to court. You remember that? The summons with complaint against her and 2 employees, Mayapath and Beck. Purvis is saying there was a question as to the service. There was nothing wrong with the service, I tell you. They were fugitives and they were lying. The court clerk, Thomas Mallon, was present. Criminal clerk, Stephen Kellner was present. Carl Anderson was the court stenographer. There were 5 New York state court officers present. There may have been a couple of other people in the courtroom who looked like lawyers. Purvis, I did not answer the complaint within 20 days. Now you notice that he admitted this, folks. So I tell you, they defaulted, but the crooked judge let him get away. I submitted interrogatories, pretrial procedure, EBT, initiated by Glendora, and I opposed it. And Glendora says, this is not so. He never opposed it. He just ignored it, along with the fugitives Hubbard, Beck, and Mayapath. Purvis, I made a motion to dismiss on no cause of action. It was decided by Mr. Justice Colabella dismissing the complaint. It's frivolous. I thereupon prepared an affidavit that the time I spent on this lawsuit was 22.5 hours. I submitted a bill for $200 per hour for $4,500. How much more crooked can anything get? It does not include phone calls. It's worthy of a lawsuit. I appeared in March at a hearing and sent Glendora a copy of the transcript. Colabella, are you licensed to practice in the state of New York? Now, to me, folks, that's a little late to be asking that, don't you think? Isn't it, Judge Colabella? Purvis, yes. Glendora asked, where's the proof? Colabella, as of when? Purvis, 1959. Colabella said something about he found the lawyer's fees to be fair and reasonable. Purvis was short, a lot shorter than March the 6th, 1995. Minutes showed him to be then. Well, thank heaven that he was shorter. Glendora was prepared to ask the court stenographer to read the record, but Purvis did not say anything of substance. He showed poor memory. Note here that Glendora's robust objection, having no hearing, won her the hearing. Glendora won on that point. It was serious business of Colabella not to give Glendora proper notice of the hearing so that Glendora could be there. So he retrenched on that after vehement protest. He was really in hot water on that matter. It's a good idea to listen what is being said. Jot just a few notes, and then have the court stenographer read back the 50 words at a time, refute that, and then go on to the next 50 words. It was about 11:25 a.m. when Judge Colabella told Glendora to cross-examine Purvis. Glendora stated that she had come in to state that her action was not frivolous and mentioned the application of June 26, 1995, Monday. And mentioned that it was not frivolous and that she was about to show that, and mentioned her application of 2 days ago, Monday, June 26. Colabella was hasty to state that the only thing he signed on that were the subpoenas. So Glendora's plan was all thrown off, and Glendora said to Judge Colabella, I need time to adjust. A minute. Glendora started thinking how to rearrange everything in a minute, like a preacher in a pulpit who was found out at his 20-minute sermon has to be cut to 15 minutes. Cola said to Glendora after the first 30 seconds, you can have more time if you need it. Glendora says, no, let's see what I can do in the next 30 seconds. And to the dot, Glendora said, Mr. Purvis, did you say Elizabeth Hubbard is a friend of yours? Purvis, yes. Glendora, how long have you known Elizabeth Hubbard? Purvis, since the 1950s. Glendora, how did you meet? Purvis, she married my roommate in college. I was the best man at the wedding. Glendora, if it had turned out that Elizabeth Hubbard had lost and had to pay attorney's fees, would you have charged her $4,500 attorney's fees? Purvis, no, I wouldn't have charged her anything. Glendora paused a half a minute on that one to let it sink in. Glendora, Mr. Purvis, did you testify that you had to spend considerable time looking up cases on volunteers? Purvis did not seem to know. Glendora, do you have a computer in your office? Purvis, no. Glendora, is it so that with a computer LexisNexis you can press a button and in a minute out comes all the voluntary ammunition you need? Purvis, I don't have LexisNexis. Glendora was getting too close to a good point for Colabella. Colabella intervened in defense of Purvis. Glendora said her point was that she was being charged $200 an hour, and without a computer, Purvis was taking too many hours looking up volunteer laws. This is the cross-examination by Glendora of Edmund Purvis, showing clearly to Judge Colabella that Purvis was not worth $200 an hour, and that there was no way that Glendora should have to pay him for $200 an hour. Glendora, Mr. Purvis, do you have a log of the hours you spent, the dates, and what you did? I keep a diary. You keep a diary? Do you have any witnesses as to the time you spent? Purvis mumbled. Judge Colabella interceded in Purvis's defense again. Glendora, were you... courts and the legislature, because we're all liars. Remember that? And we all stick together. A Americans for Legal Reform is right. Lawyers are causing most of the country's problems. So now we have to go to Coppola 2. Excuse me. We should go to Coppola 2, but the appellate division mixed them all up. And their bizarre decision, where they just rubber stamp all of the lies and all of the stupids of the Westchester Supreme Court Judge Coppola and those of the lawyers. And this case is also against the New York State Division of Housing and Community Renewal. And here is about 20 hours work and robbery of our time and peace and relaxation. This is Glendora's answer. State of New York Court of Appeals, Glendora plaintiff appellant against the New York State Division of Housing and Community Renewal, Governor Mario Cuomo, Angelo J. Aponte, David Ayala, Joseph Fernandez, Barbara M. Mays, and Carol Short. How you doing?